Good afternoon, everyone. I welcome you all to the webinar of ICSI Institute of Insolvency Professionals on the topic Anatomy of IBC Cases. In this webinar, we will be discussing recent landmark judgments of adjudicating authorities relating to IBC. Today, we have with us Ms. Prachi Wazalwar and Mr. Nipun Singhvi as faculties. We also have Dr. Prasant Sarangi, Managing Director of ICSI IIP. So the first session will be of 1.5 hours and the same shall be taken by Ms. Prachi Wazalwar. I'll briefly provide you the introduction of Ms. Prachi Wazalwar. Ms. Prachi Wazalwar is a corporate lawyer. She is a qualified company secretary and has an LLM degree from Pune University. She specializes in corporate litigation, including corporate insolvency matters, operation and mismanagement matters, winding up matter, resolution matters, mergers and amalgamations, and other corporate and commercial matters. She also handles wide variety of commercial contracts and national and international arbitrations and handles a variety of corporate cases before Honorable Supreme Courts, High Court, National Company Law Tribunals, National Company Law Appellate Tribunal, Special Courts, etc. She has handled around 300 plus cases relating to the IBC and over than 1,000 cases under the Companies Act 2013. She has handled matters of large number of listed, unlisted Indian companies and MNCs. Ma'am, you may now start the session.
Yes, thank you for the introduction. Firstly, good afternoon to all of you. It's a pleasure to be here amongst all IPs and professionals to discuss the case laws and the leading judgments that have been passed in the recent times. So, what we will do is let us understand that there are three judgments that we are going to discuss in this 1.5 hour. Are you able to hear me?
Yes, ma'am.
Yeah, all right. So, what we are going to do is they're very interesting judgments. So, let's see what is the flavor of the judgments that we are going to be dealing with. There are three judgments today in this 1.5 hour that we will be dealing with. What are those judgments? The first judgment is regarding that that issue that has gone on for the longest time, which is like secured creditor versus financial creditor, and in a resolution plan, how do you deal with such kind of an issue where if a person is not a financial creditor, if a person is not an operational creditor in this case, what is and how is it that we are going to protect their interest, and what is the stand that they can take? So this is the case of Vistra, which we will be dealing with. As you all know, Amtech Auto is a I'm just going to be sharing. Just 1 second. Let me just see if I can share the presentation. Hold on, please. Just 1 second. I wanted to start the PPT presentation because to understand any judgment which has been given by Supreme Court, we have to go back to the NCLT order. And that's why what I have done is I have downloaded all the judgments starting, like for Vistra also. We are going to start by what NCLT has held, then NCLAT, and then Supreme Court, because that will give us a flavor for understanding exactly what are we going to see. Just 1 second, entire screen share. Yes. Are you able to see this?
Yes.
Yes. All right. So now first we are going to start with the Vistra versus Dinkar Venkata Subramaniam's matter. Now this entire CIRP process, first let us start understanding what exactly was this issue about, because this judgment in NCLAT in Supreme Court deals only with the law points. But to understand this judgment in Supreme Court in its entirety, we first have to understand certain facts. So let us start by understanding what exactly transpired in NCLT and what issues was taken up till the NCLT and the Supreme Court stage. So let us see these facts which are there, which we have pulled out from the NCLT judgments. Yes. So there were two companies, WLD Investment and Brasco. These companies were group companies of Amtech Auto. Now, here, this entire judgment revolves around the CIRP process dealing with Amtech Auto. Amtech Auto went into was there was a resolution plan which was approved earlier with Liberty Group, which did not go through, and thereafter there was another resolution plan which Supreme Court permitted them to file, and the Deccan Value had given one resolution plan which was finally approved. So, what had happened in the meantime is that there were two group companies, WLD Investment and Brasco. Now, these companies took a loan facility of 500 crores from two entities. And for those two entities, there was a security trustee agreement because pledge was created and security trustee was nominated as Vistra. And that's why Vistra has been filing these cases in NCLT and NCLAT and has gone up till the Supreme Court stage. So a pledge was created. Now these Brasco and WLD took a loan from Vistra and its lenders. This loan was secured by a pledge. There were various other securities given by Brasco. There were several other securities given by WLD. But here, with respect to Amtech Auto, what were the securities which were given for the purpose of securing this loan, which was taken by Brasco and WLD? That was a pledge of shareholding held by Amtech Auto. So Amtech Auto held 66% shareholding in a company called as JMT Auto. So this was a pool of investments that it had. That is 66% shareholding in JMT Auto. This investment was given as a pledge to Vistra and the lenders for the purpose of securing the loan facility of 500 crores, which was given to Brasco and WLD, which are group companies. Now, after Amtech Auto, it went into CIRP process in 2017. Immediately after it went into CIRP process, Vistra filed a claim under Form C, claiming an amount of 500 crores. Now, they filed Form C. They said that, look, we have a pledge over the shareholding of 66%. The amount which is secured by virtue of this pledge is 500 crores, and therefore our claim under Form C, we are a secured financial creditor for the purpose of this 500 crores of debt. Now, this claim was rejected by the resolution professional. They did not go in for an appeal in 2017. They waited and watched. After this, an information memorandum was set out. In the information memorandum, this fact that the pledge agreement, there is a pledge agreement by which this shareholding of JMT Auto. Are you following me, or should I go back to the facts? Because these facts are extremely important. All of you?
Go back to facts, madam.
You want me to go back to the facts?
Yes, yes.
Okay. So let me just give you a brief background again. There were two companies. We'll call them company WLD and Brasco. Okay? These were some separate companies. We are talking about, have we understood that this is the CIRP process of Amtech Auto that we are dealing with? All of you? This is the CIRP process of Amtech Auto Limited. Yes. Okay. Amtech Auto had given pledge of certain, like Amtech Auto has various assets. Out of all the movable and immovable assets, it has one asset which is the shareholding in JMT Auto. So it held some XYZ number of shares in JMT Auto. Now, sometimes what happens is now it had group companies. So what do certain group companies do? They either give their corporate guarantees or they give certain assets as collaterals. So similarly, what Amtech Auto did was there were two companies which wanted to take a loan. Amtech Auto wanted to support them in the loan that they were taking. So for that purpose, what they did was they gave this asset, which is the shareholding which they have of 66% in JMT Auto. They gave this shareholding, which is a as a pledge for the purpose of securing the loan facilities of these third companies, so of these group companies. All right, correct? Are we clear on that? You'll have to tell me because then we can move
Yes.
forward.
Yes, sir.
Okay, all right. So this is the fact of the case that Vistra had a pledge over 66% shareholding of JMT Auto shareholding, which is an asset of Amtech Auto. So they filed a claim saying that we are a secured creditor, we have this pledge, and this pledge is for securing the loan which we have given to its group companies of 500 crores. RP said nothing doing, this is only a pledge. You are not a secured creditor, you have not given any monies to Amtech Auto per se. So we are rejecting your claim, we don't accept it. Vistra ITCL did not file any appeal against this judgment. Okay, this rejection of claim by the RP. However, the fact like when RP prepares a resolution plan and he prepares an information memorandum for the purpose of a resolution plan, he generally puts all the details in the information memorandum. So, in the information memorandum, he had put forth this fact that look, the company has multiple assets. Say it has a land in one place, it has certain factory and buildings at certain place, it has certain plant and machinery, and also it has these shares in another company, JMT. So these shares are subject to a pledge. This fact was mentioned in the information memorandum. Now, in this particular case, there were two bidders which had come forward. One was the Liberty House Group, and another was one was the Deccan Value Investor Group. So, in the first round which had taken place, Liberty House won the bid. Now, in Liberty House's bid, what they do is they mention that what are the assets, what are the securities, which securities will go out, which security will continue. So, in that there was a reference to this pledge given to the applicants, which is Vistra. All right. So therefore, Vistra said, why do we have to do anything? Our asset, the pledge has been continued. By virtue of this resolution plan, we need not file our objection to the rejection of the claim. We need not do anything. They sat tight. Now what happened is Liberty Group, they had given a resolution plan. That resolution plan was approved by adjudicating authority, but that the plan which was approved was finally rejected because they were not able to, like, it was approved, they failed to implement the plan, and therefore finally it was decided that Deccan Value investors will be given a chance, and Deccan Value investors were allowed to give a resolution plan for the purpose of Amtech Auto. Now, when they gave a plan, so when they gave a plan for the purpose of this company, they did not mention anything about this pledge. They did not take into consideration the pledge of the shares, and they did not agree to continue the pledge over the shares. So Vistra came into action. They said that look, in the resolution plan, there is no reference to this particular pledge which is there. So what is the status? Why are they not considering this pledge? RP said that look, we have informed in the information memorandum that there is a pledge on the shares. Now we cannot say how Deccan Value Investor wants to structure the resolution plan. That is a subject matter of Deccan Value Investor. I cannot have any say. I have mentioned all the assets and all the pledge that are there in the company. So now Vistra came into action, and this had happened in 2020. So if you just go back, you will see that 2018 Liberty House Group, their resolution plan was approved. Then you will find that this plan failed, and then Deccan Value Investor came sometime in 2020. So Vistra did not challenge Form C rejection of claim in 2017. In the meantime, it was 2020 before another resolution plan of Deccan Value Investor was approved. So now the question was, now as Deccan Value Investors resolution plan did not contain any security for the purpose of this pledge. Applicants, that is Vistra, came into action and they filed an IA in the NCLT. So let us see what was that IA. Yes. So this IA this what at page number 17. See, now this was the IA which they filed, where they gave all the details. Yes. So Vistra filed this IA. They sought this relief that direct the resolution professional. And please understand that they had filed a claim as a financial creditor in 2017. In 2020, they had come to court and they had sought this relief that resolution professional be directed to include them as a part of the COC as secured financial creditor and afford them all the right as a secured financial creditor. Technically, we must understand that they were holding a pledge on certain assets of Amtech Auto. So, till the time this pledge was mentioned in the resolution plan, they had no objection. It was only in the second resolution plan, which was filed subsequently, where there was no reference and their rights were not protected as pledger. Only then they came into action and they filed this case. Now they mentioned all these facts that there were three trusteeship agreements. Based on this, we have given loan to certain third party companies. But this company has given this company Amtech Auto has given a security, and ultimately they also made one statement in the application which they later on used up to the Supreme Court stage, that look, this 500 crore loan which was given to WLD and Brasco was ultimately used for the benefit of the corporate debtor. They tried to take advantage of this fact that these loans which were taken were ultimately for the benefit of corporate debtors. So though loans were given to third party, the benefit was derived by corporate debtor. So they said that look, we are a secured creditor, and because we are a secured creditor, and because we have given loans to company A and B, and that company has ultimately used that money for the purpose of Amtech Auto, therefore we are also financial creditors, and we should also be considered as financial creditors. Right? Now look at the objection which was taken by the resolution professional. So let us go to the objection which was taken by the resolution professional. That is at para 6. Just one second. So resolution professional has informed them that it is for the resolution applicant submitting the resolution plan to note whatever are the details in the resolution plan. I will not be able to ask them to include that pledge which is created over the pledge shares. Further, he said that there is delay and latches because look, you had filed a claim in 2017. When I have rejected that claim in 2017 itself, you cannot raise this grievance after these many years, right? And you cannot be permitted to take a challenge. You cannot be permitted to take action today. So the court said that is true. You have not given, you cannot be a guarantor or an indemnity. You have not given any guarantee or indemnity. Just understand one thing, that if company A has given a corporate guarantee for company B, then the person who has given who has taken that guarantee, that bank can file a case against company A also and company B also, correct? because corporate guarantee, if you have given, your liability is coterminous with that of the original principal. So if there is a corporate guarantee, then of course the person who the company, the banker can file a case against both the principal debtor as well as the guarantor. But they said that when there is only creation of a pledge, that is not a guarantee. That is not an indemnity. That is only concerning one particular asset, which is the shares of JMT. So you have certain rights only with respect to the shares. You have not given any guarantee and indemnity. And under the terms of financial debt or a financial creditor, only guarantee and indemnity are financial creditors. Rest of them, just creation of pledge doesn't make you a financial creditor. That was their say. They further made a statement that look, this was for third party, that this collateral was given. You have not lent any money to the corporate debtor, so we cannot treat you as a financial creditor. So, on this basis, the resolution professionals' submissions were taken into consideration. Vistra lost in NCLT. Now they filed an appeal in NCLAT. Are you following me? Are you following me?
Yes, 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 ma'am.
Yes, we are following.
Yes, ma'am. Yes, ma'am.
Have we understood the facts? Because understanding the facts is extremely important
Yes.
in this
in
particular.
addition to the article. So that's the CO.
Okay. So now let us see what NCLAT said. Now Vistra again moved to NCLAT. In NCLAT, they raised the same submission. What did they say? That look, when you have given a pledge, they gave that entire fact that now Deccan Value Investor is there. They have not considered the pledge, and they have not allocated any money to me, and all those things were under challenge. So that is why they filed this appeal. They said that we are challenging this resolution plan, and we are also financial creditor, and without making us a financial creditor, this resolution plan cannot go through. And that was the entire crux of their judgment, and they harped on the fact that we are a financial creditor. So the entire NCLAT judgment was dedicated to whether they are a financial creditor or not. Even here, resolution professional raised the same type of raised the similar queries, which similar issue. They said that you have not given a guarantee, you have not given an indemnity, you have simply created a pledge. Then they said you have not advanced any monies to the corporate debtor as a financial debt, so you do not come within the purview of a financial creditor. You will have to show, for the purpose of being a financial debtor creditor, you will have to show that you have given some debt along with interest, and this is a basic ingredient of a financial debt. So without that, I cannot consider you to be a financial creditor. So based on this, even the NCLAT decided that Vistra has no standing. Now the matter went up to the Supreme Court. Now Supreme Court took note of all these facts which have taken place, all right, and they raised a question. They first considered, now we'll go to that. They first considered two judgments. Let us see the first judgment, which is Anuj Jain. That is the JP matter. So they said, now let us understand what the appellant said. The appellant said that look, this issue of debtor creditor relationship of Amtech Auto and appellant has to be decided, but it has already been decided in Anuj Jain's case. So they said that we are a creditor, because the question was then, when a pledge has been given, like they have not taken a loan, they have only given certain collateral, which is an asset, which is shares, which they have given as a pledge on their shares. So they said that that creditor relationship itself doesn't, there is no creditor debtor relationship between Amtech Auto and Vistra, because they have not taken anything from you, they have simply given you a collateral. So for establishing a debtor creditor relationship, there is nothing that you have. There were two judgments, one was Phoenix and one was Anuj Jain. So let us just see. I'll just show you the relevant portion because that will give you certain details regarding how they have interpreted this judgment. One issue which they had discussed is that when we have given a pledge, we have a continuing cause of action. So even if the claim was rejected in 2017, we have filed the case in 2020, it doesn't make a difference because that pledge continues. That objection was thrown out by the Supreme Court. That's a nothing doing. When you have filed a claim and your claim is rejected, it is not a continuing cause of action. You had to file immediately. So you cannot say that I will file after 3 years. So that objection was immediately overruled by the Supreme Court. Now, the second objection which they have taken was regarding these two judgments. They said that, just one second, I'm just trying to find out the relevant portion because that portion is important. We will read out this particular portion of Anuj Jain because the parties have relied upon this part of Anuj Jain's judgment. So this is para 14. This has been para 14 of the order, wherein they are saying that when the lenders of holding company, they said financial debt as per section 58C, 58 of the code, this issue has arisen, whether the mortgage has been given for the creditors and whether just when a mortgage or a collateral is given, whether they are financial creditors. So here it was held that financial creditors are only stakeholders who are obviously concerned or concomitant with the resurgence or restructuring of the corporate debtor. Secured creditor may only have an interest in realizing the value of the security. So this is a very important distinction that Anuj Jain judgment has created, which they were trying to rely on in this particular case, right? So they said that who are financial creditors and who are secured creditors. Financial creditors are different, secured creditors are different. So if, for instance, a company has given a collateral, like in this case, uh, in this particular case of JP, they had given a mortgage, correct? Mortgage on certain lands. So they said that there is a difference when if Amtech Auto had taken a loan from somebody, that financial creditor is different. And if Amtech Auto had given, say, a security, for instance, a pledge on its shares for the purpose of loan taken by XYZ, those two parties are completely different. One is a financial creditor, they have an interest in restructuring the corporate debtor. Another one is holding only a security, that is a pledge. So, what is their interest? They are not interested in reviving the company, they are only interested in realizing the value of their security. Correct? So, in this particular case, they tried to make this distinction between a financial creditor who has given loan or who has taken a guarantee for the purpose of certain loans and a person who has only given certain assets of the corporate debtor as a security or as a collateral for loans taken by third parties. So, thereafter, they say that while the financial creditor, apart from looking into the safeguards, will simultaneously be interested in revival or growth. Therefore, a person with only security interest in the assets, even if falling within the description of a secured creditor by virtue of the collateral security extended by the corporate debtor, would nevertheless stand outside the sect of financial creditors and consequently outside the COC as well. So, this was the decision in Anuj Jain, which was considered in this particular case. Then they also considered Phoenix because Phoenix also has tried to distinguish between who is a financial creditor and who is a creditor other than a financial creditor. Because as we have seen in this matter of rainbow judgment, we have seen that court has considered that even an operational creditor can be a secured creditor. So in this judgment also, they have considered that a creditor who is not a financial creditor, who is not an operational creditor, can also be a secured creditor. So let us look at Phoenix ARC judgment. Here they have said that what is a contract of guarantee? Contract of guarantee is a contract for performance of a promise or discharge of a liability of third parties in case of a default. Right? So here in Phoenix ARC judgment, Phoenix ARC had a pledge over some 40,000 shares as a security. They tried to file a claim and they said, we are also a financial creditor. They tried to take advantage, saying that this is also like a contract of guarantee and indemnity. Court said nothing doing, contract of guarantee and pledge stand on a different footing. You are not a guarantor. Why? Because contract of guarantee contains a performance of a promise or a discharge of liability of a third person. This is not what you are doing when you have given a pledge. A pledge does not give any such guarantee to perform a promise or discharge a liability. It only gives you an asset which you can realize. That's it. It doesn't give you anything more than that. And therefore, you cannot use guarantee and indemnity as a clause under which you would like to file your claim under Form C. That is not permitted. So now, after considering all these judgments, Supreme Court now really raised this issue that what do we do now? Because they have considered the entire factual matrix, right? So here they come to a decision with respect to what to do now in the resolution plan. So they have dealt with that in para 24. There is the para 24. Just one second. So here they have mentioned, just one second. I'll just explain what it is, but I want you to read what they have mentioned because they have very beautifully dealt with this issue. That is in para 33. Let's just see para 33 first. I want you to read this paragraph because that will give you a very clear-cut understanding of what was the issue in this particular case. Yes, here we are, 32. Yes. So this is where the court has now tried to understand that court firstly tries to say that trying to why are we trying to today try to find this resolution whether you are a financial creditor or not, because ultimately Vistra is saying that look, I am a secured creditor, right? Under 30 subsection 2, what does 30 subsection 2 subsection 1 say? That if a person is agreed by a resolution plan or dissents to a resolution plan, what does the section entail? They say that if it's a dissenting financial creditor, that person will be paid as much as the liquidation value. Correct? In 13 subsection 2, what are operational creditors required to be paid? Without going into the basics, ultimately operational creditors are supposed to be paid as much as the value of liquidation, what they will get in liquidation. Similarly, if it is a dissenting financial creditors, what is the value they will get? They will get the value as much. If it is a dissenting financial creditor, they should get as much as the value which is equivalent to the liquidation. So today, if the company was liquidated and a financial creditor is entitled to get 10 crores, and in the plan he should get minimum 10 crores. If he dissents, he should get minimum 10 crores, not less than that. Otherwise, the plan is not in accordance with the law. So here the court said that when there is a pledge, I am faced with a difficult situation. Why? Because now Vistra today is a secured creditor. Because who is a secured creditor? Any creditor who has a security interest. So I definitely agree that Vistra is a secured creditor. But Vistra is not an operational creditor because there are no goods or services which have been offered to the company. It is not an operational creditor. It is not a financial creditor because we have decided that guarantee and indemnity are different. Pledge is different. Pledge creates only a right to that particular realization of that particular asset. So this is not a guarantee, not an indemnity. So you are not a financial creditor. But section 32 only talks about these two types of creditor. It says if operational creditor, he should get at least up to his liquidation value. Financial creditor should also get, if it is a dissenting financial creditor, he should also get a value equivalent to the liquidation value. But now what to do with Vistra? Because Vistra is neither financial creditor nor operational creditor. But they are saying that ultimately, and that's why they have gone back to the liquidation, the law regarding liquidation under section 53. They have said that look, ultimately we understand that if this company goes in for liquidation, Vistra was a secured creditor, they could have taken this pledge away from the liquidation and sold this property. So in liquidation, they would have got this asset and the value equivalent to the realizable value of this asset. But now you're telling me in the resolution plan, they get nothing. So this is a tricky problem. So that is where if we just read this, they have very beautifully interpreted this catch 22 situation which they were facing. So let us just see this particular paragraph where very beautifully they have explained what is the problem and they have given a solution also. So in para 33, we are presented with a very difficult situation. Vistra, a secured creditor, is being denied rights under 52 as well as 53 of the code in respect of pledged shares. Whereas, what is the intent of section 30 subsection 2 read with section 31? It recognizes to protect the interest of other creditors who are outside the purview of COC. To our mind, this answer is a tricky twofold problem. First, to treat first is to treat the secured creditor as a financial creditor. So if you want to protect the interest of Vistra, what are the solutions that come to the mind? First solution is that you treat this secured creditor as a financial creditor to the extent of the estimable value of the pledge from the date of commencement of CRP. However, this will give it voting rights, which is equivalent to the value of their pledged shares. However, they said that if we pass this judgment, this will be completely contrary to what has been decided in Anuj Jain and Phoenix ARC, that this particular person has only a right to the asset and has no interest in the resolution of this company. So this will completely go against Anuj Jain and Phoenix. So if we are to decide in this manner, we will have to change the entire law, for which we will have to constitute a larger bench. So that option is, it cannot be used. So this option is not viable. They said, what is the second option that is available to us? The second option is to treat applicant number one, that is Vistra, as a secured creditor in terms of 52 as well as 53, and we give them an option to the resolution applicant.
Deposited with the HSBC.
So you give an option to Deccan Value Investor to treat Vistra as a secured creditor. They will retain. They can be given two choices.
Third Saturday is a working day, so we can avoid it. Yeah.
Yeah. So
Okay.
I think somebody's phone is on. Can you please switch it off? So Vistra, so Deccan Value Investor as a resolution applicant was given two choices. One, that Vistra is a secured creditor, you give them the security interest over the pledge, you retain their security interest, then you don't have to pay them anything. Or else, what you do is you give them the liquidation value of the security proceeds. So, whatever these shares will fetch as on today, you give them that much value and whatever proportionate haircut. And that is how you can treat this particular secured creditor. And therefore, this issue of whether they are financial creditors, not financial creditors, all these issues will get resolved, and Vistra's right as a secured creditor will also get safeguarded. So this was the just one second. Yeah. So are there any questions on this particular judgment? And this is a very important judgment because many a times who are financial creditors, who are not financial creditors, is a very important question that any RP faces over
Yeah.
everyday basis.
Can I
So
ask?
yes, yes, please go ahead.
Yeah. You're treating him as a secured creditor and paying him off to the extent of security, whatever
Yes,
is provided under Section 53.
yes,
And
realizing the value of the security.
but court has not adjudicated him as a financial creditor. It has not gone into that. It only
No,
said that
no,
he
no.
cannot
It
be
has
a
gone
financial
into that.
creditor.
No, no, it has gone into that and decided that if you have just given up, because see, many a times companies give collateral for loans taken by third parties.
Correct.
This is like a regular thing. You give collaterals, correct? So
Yeah.
this issue of how do you treat what is the status of these people to whom you have given collaterals is a question which will be faced in several matters.
Okay. Yeah. So
This
they
is
will
the
not be a
issue.
member of. No. See, they will be a member of COC or not. They will not.
They will not. If you have
So
given only
without
a
being of a
collateral,
member of COC, with neither a financial creditor nor an operational creditor, they'll be entitled to the amount which or the value of the pledge.
exactly, exactly.
Okay.
So you will have to mention them because this is a very tricky situation. They are not either of the two creditors. They are not. So ultimately, if you hold a, say for instance, now what do you do when now for instance as an RP today when you're sitting in the CIRP process for any company, you will ultimately reject their claim. Anybody who has given a collateral, you'll reject their claim as a
Yeah.
financial creditor. They will not be
Yeah.
able to file as an operational creditor.
So
So
with this
what
judgment,
what
they will be entitled to the amount of security.
yes,
Okay.
exactly. Yes, exactly.
फाइन लगती नहीं है 10th में.
So what is it? So how will they file their claims? That is another question because in this case, Vistra filed it as a secured credit, as a financial creditor. Claim was rejected, but ultimately court considered that they are a secured creditor. But if today somebody has given a collateral and as an RP somebody is taking your advice that okay, this is the bank, this bank has given this collateral secure, this particular collateral has been given to this bank, and that company who has given the collateral has gone in CIRP. So what should we file? That is the question. So what should you file? What type of claim can you file? So
There
you will
is
Reject.
file,
Other
other
creditors, they can
creditors
file.
is
Other
there. No, there
creditors.
is one
correct. So as
other creditors,
other creditors,
FA or something. I don't remember the form.
so you will have to file as other creditors, and
Yeah.
in that you will have to mention that there is a security interest because that is most
Correct.
important. Because unless
Yes.
you mention that this particular whatever is that amount is secured, you will not get advantage of this particular order.
So that classification of other creditors has come only after this judgment.
No, no, it was there beforehand because
Oh,
at that time, how will shareholders file if we are not financial creditor, operational creditor? Because this is a judgment
okay.
recently of 2022-23. But this issue, this other financial, the other stakeholders, this form had come long time back. But this judgment has
Yeah.
provided clarity that even such kind of people who hold collateral, they will have to file as other creditors and not as financial creditors,
Not as financial creditors.
not as financial creditors.
Is that form FA? I don't remember. What is that form?
I'll just give you that form number.
Yeah.
As other financial creditor, there's one separate form which is given for them.
Correct.
So this is where we have dealt with this particular issue of pledge because pledge is something which is given in so many matters and it has been a subject matter of so much of controversy that now the court has finally given some clarity on this particular aspect. Now let us look at the other judgment that we are going to deal with. I'll just start my screen sharing. Hold on. Are you able to see my screen?
Yes, madam.
Yes.
Yes. Okay. Now, the second judgment that we are dealing with is regarding Section 7 admission denial. And this comes after the judgment of Vidarbha Industries. So, ultimately when it goes to the Supreme Court, they have dealt with Vidarbha Industries and whether it is applicable, and whether based on Vidarbha Industries whether section 7 can be rejected. But as of now, let us look at what the NCLT has said and what was the issue in this particular matter. So this is concerning the section 7 proceedings filed by Syndicate Bank, thereafter Canara Bank, against a company called as Kranti Edifice Private Limited. So Syndicate Bank filed a case against Kranti Edifice. When they filed the section 7 against Kranti Edifice, the corporate debtor raised certain issues. They said that, look, we have certain, what is the kind of facilities that we have taken from Syndicate Bank. They said we have taken two types of facilities from Syndicate Bank. And please understand that this petition, if you see, was filed in 2020, and the ultimate decision of the Supreme Court has come in 2023, but it has given a lot of clarity regarding multiple issues. So let us see what has happened in the NCLT at that stage. So first, Syndicate Bank filed a case against the corporate debtor. Corporate debtor said that, look, we have two types of facilities which we have taken. They agreed that yes, we have taken facilities. We have taken two types of facilities. One is an overdraft facility and one is a non-fund liability which we have taken, which is a bank guarantee. So they were doing various projects for government. For that, they were required to give bank guarantees. Now, corporate debtor is saying that these bank guarantees were not required to be invoked because now just let me give you a background of this matter. That irrigation department, I'm just taking an example, irrigation department was given bank guarantees by the corporate debtor. Irrigation department, when the bank guarantees were about to expire, filed an application with bank. They said, kindly extend and revalidate my bank guarantees. The bank didn't do that, and these bank guarantees were finally encashed. Now, the corporate debtor contains that financial creditor has illegally fastened this liability on me because the irrigation department had not asked it to invoke the bank guarantees. They had asked for an extension or revalidation of the bank guarantees. You did not revalidate it, you did not extend it, and simply gave them a check for the entire bank guarantees, which was not what they were asking for in at all. Further, they further make a statement that these beneficiaries to whom you have given the money with respect to that bank guarantee are ready to return the check. So if, say for instance, a 10 crore bank guarantee has been given by Syndicate Bank for the purpose of a project to the irrigation department. Irrigation department says that, okay, look, this bank guarantee is expiring in the month of May. Kindly extend it. Bank says nothing doing. They give a check for that money to the irrigation department. Irrigation department is now saying that we are willing to return this demand draft because we never intended to invoke it. We only wanted to revalidate or extend these bank guarantees. We do not want the money. We want the security because this is for certain projects that we are doing for security purpose till completion of work. As per the contract, we are required to maintain these bank guarantees as securities. So that is why we need revalidation of this security. So corporate debtor said that ultimately they have filed in high court also. They have said that this is wrong. That when a bank guarantee is being given and we are only asking for revalidation, you cannot unilaterally decide that no, you want to invoke the bank guarantee and you cannot make the payment to the department. And when you make such a you do such a thing like invocation and you pay the money to them unilaterally, when they also don't want it, we also don't want it, then in that case, based on these facts, you cannot file an IBC petition against me, and this petition is completely malified and fraudulent. Okay, they say that this petition is contrary, this action is contrary to the terms of the bank guarantee. It is malified, it is fraudulent. And please understand, along with this company petition, when a section 7 petition was filed by the banker, simultaneously the corporate debtor filed an application under section 65. saying that this is fraudulent initiation of the CIRP process. So that judgment is also there, which I'm not going into. But again, they have said that nothing doing, this is validly invoked. So that aspect I'm not going into. But they had also filed an application under section 65 saying that this is all illegal and bona fide. Why are they taking action against me? You just return the bank guarantee. They are ready to return the bank guarantee money. You please just extend the bank guarantees. Now, this was the entire reason because of which this process continued for some time. There was back and forth between the parties, but ultimately the court decided that look, you have taken overdraft also, you have taken bank guarantees also. Whatever way you have defaulted in repayment of public money, so we are not going to go into the invocation, whether it is valid, whether it is invalid, all these things we are not going into all that, and we are admitting the CIRP process. Ultimately, the CIRP process was admitted in June 21. So, based on that, they filed an appeal. The promoters went and filed an appeal in NCLAT. Now, in NCLAT also, they have ultimately shown all these facts. What are the facts that they have shown? That look, this bank guarantee ultimately should not have been invoked because just one second. Here they have tried to distinguish the same issues were raised in NCLAT that look, when you have unilaterally invoked and given these bank guarantees, then I am not liable under section 7 and there is no default. They said that there is no default because nobody wanted the invocation of this bank guarantee. They had not asked you for the invocation. So unilaterally when you have paid them money, that doesn't constitute a default. Another issue which was raised before NCLAT is that we had given them OTS proposal of 55 crores and we have already paid them 5 crores out of that. So all these issues should be taken into consideration that we don't want a section 7 insolvency. We are ready to settle with them, but there are issues that are there. One of them being that this invocation of bank guarantee is invalid. So based on that, they tried to argue this case. Now, the banker tried to bring out the distinction, the facilities which were given to them. They said, look, we have a secured overdraft facility of 12 crores. We have a bank guarantee limit of 100 crores. Collateral securities of 19 properties and all that. So they said this is what we have given to them. This is the facilities that they have given. They have given an overdraft, they have given a renewal of the overdraft, and they have given bank guarantee and renewal of bank guarantee. All these things they have given. They said that all right, even if you consider for time being that these bank guarantees have been wrongly invoked, still they say that we have a secured overdraft facility which you have taken, which can be seen here. They said, have you paid this amount which you have taken as a secured financial facility of overdraft facility of 12 crores and whatever is the interest on that? That also has not been paid. So they said that we don't need to go into the details of this invocation of bank guarantee and illegal invocation of bank guarantee or the return of money. Because they said ultimately we just have to see debt and default, and we have to take debt and default as is available, which is more than 1 crore. And if you consider only one facility, which is the overdraft facility, even then the amount is more than the threshold limit, and therefore invocation, not invocation, illegal invocation need not be gone in. Against that, under para 17, they also made the RP made one more submission that corporate debtor has acknowledged this fact in their balance sheet. So when bank guarantees were there and overdraft facilities were there, whether invocation was wrongful or rightful, without getting into that, let us look at the books of the corporate debtor. The books of the corporate debtor also show that there is an amount of 63 crore which is pending. Has that 63 crore been paid? So that's how, without going into all this, we can see that there is a debt and default. even if the amount of bank guarantee is not considered, even if nothing is considered, as per their balance sheet also 63 crore is due. Show whether where they have paid the 63 crore, otherwise dismiss the company appeal. And on that basis, NCLAT said that yes, debt and default can be seen, and I will have to dismiss this appeal. I can see the debt and default, therefore admission by NCLT is correct. So now the matter goes to the Supreme Court. Now in Supreme Court, during this time, Vidarbha judgment has been passed by the Supreme Court. So the promoters try to take advantage of the Vidarbha judgment and mix it with this illegal invocation aspect. And they say that look, this company was running, we can take advantage of the Vidarbha judgment, because Vidarbha judgment also says that you don't have to admit a Section 7 petition. You have a choice whether you want to admit or you don't want to admit a Section 7 petition. So accordingly, NCLT has the power to reject. And considering that there were so many issues in this Section 7 petition and therefore defaults on the part of the banker, so if you consider this entire scenario, the NCLT was wrong in not rejecting this NCL in this Section 7 petition. So they said that we are taking advantage of the Vidarbha judgment where NCLT had a choice, but despite having a choice, they had a choice to reject, which they have not exercised and they have admitted it. So we have an objection to this. So now in the Supreme Court judgment, what has happened is this is after the Vidarbha Industries judgment, and this is a matter where admission of the Section 7 was upheld by NCLT, by the Supreme Court, despite Vidarbha judgment, and they have revalidated what has been decided in Innovative Industries. So this judgment is extremely important because this is after the Vidarbha judgment, and it revalidates the old stand which was taken in Innovative Industries, that you just show me debt and default at that time above 1 lakh and now 1 crore. So if you show me debt and default 1 crore plus, I will admit your petition, nothing doing, I will not consider extraneous factors. So even in the Supreme Court judgment, all these aspects regarding the bank guarantee and the fact that bank guarantee validation was illegally invoked, they said, and they have made one more statement here which is important. They said bank is responsible for the default, we are not responsible for the default. It is the failure of the bank that has resulted in default. So you have triggered the default, not me. So this was another point that they said, Vidarbha Industries. Second, you have invoked, and they also tried to take advantage of this E.S. Krishnamurthy, which regarding settlement and all these talks. So they said you are bound to admit a Section 7 petition. This was the stand of the RP. And the banker said that we are relying on the Innovative Industries judgment. So court said, yes, we agree. And they have again gone back to what Innovative Industries has mentioned, which is that debt and default is what they are going to consider. They have highlighted certain portions that debt may not be due if it is not payable in law and fact. The moment the adjudicating authority is satisfied that a default has occurred, application must be admitted unless it is incomplete, in which case notice has to be given to rectify the defect and by the adjudicating authority. Right? So these were the important points which they again reiterated and highlighted in the Supreme Court judgment. They further highlighted one more part of the Innovative Industries judgment, which says, in case the corporate debtor who commits the default of the financial debt, adjudicating authority has to merely see whether there is an evidence, either records in the information utility or evidence which has been produced to satisfy that the default has occurred. It does not matter that the debt is disputed so long as it is due, payable, unless some law, because of some law, or it has not yet become due and payable, or it is due and payable at a future date. Now, this is what the promoters were trying to take advantage of, that it is payable at a future date. Why? Because they said, look, bank guarantee is there. Bank guarantee invocation was not required. So as of now, when you have invoked it and you are responsible for triggering the default, you are responsible and we have not committed any default. But here in the Supreme Court, court court found a very important aspect in this particular case. They, and I'm just trying to search for that, but just one second, they have mentioned a very important fact. They said that when irrigation department wrote to the banker, their letter has to be very carefully considered. That letter says kindly extend, failing which we are invoking the bank guarantee. So they said don't go into all these complications whether invocation is right or wrong. Look at the letter which the irrigation department has given. Irrigation department has said that you extend it, failing which we will invoke the bank guarantee. So because it is a choice of the banker whether to extend bank guarantees or not. So if they are not invoking it, they can when they are not, they don't want to extend the bank guarantees, which is the choice of the banker, they were right in trying to invoke the bank guarantees and pay the amount to the irrigation department. So that's where they are trying to, that's how they have taken into consideration this factual aspect, and thereafter they have said that based on all these factors, just one second, I'm just reading out what has been decided by them. Thus it is clarified that in view of the review of the decision, wherein it was in the facts of that particular say, the decision in case of Vidarbha Industries cannot be read and understood as taking a view which is contrary to the view taken in Innovative Industries and in ECS Krishnamurthy's matter. The view taken in Innovative Industries still holds good. This is very, very important because by the Vidarbha Industries, there was a shadow which was cast on many Section 7 petitions. In several petitions, they were trying to say that we are a very good company, we are a solvent company, we will be able to make payments. We have several, like in case of Vidarbha, many other companies also had awards in their favor which they had won. So, based on all that, they were trying to say that look, in Section 7, you consider all these corroborative factors which show that I am a strong, stable company. I am able to pay my debts, and because of that, you have a choice not to admit a Section 7 petition. So, court has gone through both these judgments, whether it is Vidarbha judgment, ECS Krishnamurthy judgment, or Innovative Industry, and they said that Vidarbha Industries, the what does the review order say? The elucidation in para 9, just one second. The elucidation in para 90 and other paragraphs was made in the context of the case at hand. It is well settled that judgments and observation in the judgments are not to be read as provisions of the statute. Judicial utterances and pronouncement are in the settings of facts of the particular case. Now, this is what was decided in the review petition of Vidarbha Industries. So, in the Vidarbha Industries review petition, court said that look, the facts of this case were completely different. Based on these facts, we have taken this decision. These facts, this pronouncement cannot be treated as a law and applied in every single Section 7 petition. So, in this judgment of this is what was finally decided. They said that when, just one second. So finally, the court, based on these decisions, finally said that we cannot continue using Vidarbha Industries judgment to shield people from CIRP process. We will have to take advantage of Innovative Industries and Krishnamurthy's matter, where the court has clearly said that debt and default, if it is there, the NCLT does not have a choice. They will have to admit a petition, and that view still stands. So, this is a very important judgment. Wherever the borrowers are using Vidarbha Industries judgment, now you can cite this judgment, and this judgment will help in bankers getting a speedier Section 7 admission of a Section 7 petition. So, this is a very important judgment from the perspective of the bankers. Here, the court has also said that even assuming that the NCLT has a power to reject an application if there were good reasons to do so, in the facts of the case, the conduct of the appellant is not such that there is any good reason why NCLT should have denied the admission of the application. Why have they mentioned that? Because in the Section 7 proceedings, as I told you, there were two facilities which were taken. One was the overdraft facility, one was the bank guarantees. So they said that if you were such a good corporate debtor and if you were such a good company, then you would have at least ensured that your overdraft facility is properly serviced. When you have not done that, because as I told you that there was a period of 3 years when this company petition was filed in 2020, a Section 7 petition was filed in NCLT, and when the final decision of Supreme Court was given in May 2023. So they said that we have looked at your conduct during all these years. So we don't find that there is a good reason why this petition should not be admitted, because ultimately these this is what they have relied upon. They said that just one second. Yes, a demand notice was issued to you not just with respect to the bank guarantees, but also with respect to the overdraft facilities. Your balance sheet also admits that yes, there is a liability towards corporate to the banker, and that entire liability, apart from these bank guarantees, is not cleared. So overall, you cannot say that I am capable of paying and I am not paid just because of this issue that you have created regarding invocation of bank guarantees does not preclude you from servicing your secured overdraft facility. And that's why we don't find any reason to take advantage or to give you the advantage of Vidarbha Industries judgment. And therefore, finally, the court decided that they do not want to consider uh, consider this case for rejection of a Section 7, and they said we are upholding the order which was passed by NCLT and NCLAT. And in fact, in this case, generally what happens is if a matter is lost in NCLT, if a matter is lost in NCLAT, generally Supreme Court uh, at the threshold itself many a time dismisses the matter. But I think this opportunity was taken by the court. This was, if you see, this was Justice Oak's judgment. He's also he was earlier in Bombay High Court. This, I think, has been an opportunity taken by the Supreme Court to explain what are the contours of Vidarbha industry and to constrict it to certain limited aspects, because that is what the court has said, that even if I were to consider that Vidarbha industry's judgment is applicable, still I can't give you that advantage because your conduct doesn't show that it is not completely above board. So I can't give you that advantage even otherwise. So this is a very important judgment which has come after the Vidarbha industry judgment. All right, so we have completed these two judgments. We have time for the last judgment, which is like a little different type of judgment. So let us see the judgment of Universal Built Well. Now, this judgment that we are going to consider today uh, before I move on to the third judgment, tell me, are we clear on this judgment of Supreme Court? Any questions about that?
It is clear, madam.
Okay. Now we go to the third judgment, which is the Universal Build Well judgment. Now let me just give you a brief background. This is the judgment of Universal Build Well. This is regarding a resolution plan approval and a challenge to the approval of a resolution plan. So the original judgment was of NCLT New Delhi, Bench 2. It was regarding the CIRP process of Universal Build Well Private Limited. In this case, there were three resolution plans. I'll just give you that background, which the court has mentioned. So in this case, in 2018, CRP process was initiated. This is a company which has multiple. Now, this particular judgment is concerning the uh, construction field, where this company had multiple construction sites and they were trying to find a way to resolve the insolvency of this particular company. So CRP was admitted in 2018. Public announcements were made. Last date, non. There were several issues which were there in this particular process. They finally put a Form G out. They got interest from three people in this CIRP process, and I will just show who are the three people. Yes, so all resolution plans were in this meeting. They have said that resolution plans were received from individual, then a welfare association. They got certain plans from welfare association. Basically, this was a welfare association of particular people who were concerned about particular projects. This company, Universal Buildwell, had 6 to 7 different projects. For all 6 to 7 different projects, there were different home buyers who were involved. When claims were admitted, as is the case, that entire set of claimants were put in one class, and for all the home buyers, one particular authorized representative was appointed. However, these projects were different. So, what they did was they created welfare associations, or certain welfare associations were created pertaining to certain different projects. So these welfare association also said that we will develop our own project, and that is how they came about to file their resolution plan. So if you see, in the resolution process, there were three resolution applicants. One was an individual who gave an overall resolution plan. Second also was a company, a partnership which gave an overall resolution plan. And third was a consortium. So consortium contained three welfare association: Universal Aura, Universal Green, and Universal Business Park Owners Association. So these people gave a resolution plan saying that we will develop our own individual assets. We will develop our own resolution. In the resolution process, we will develop our own projects. So I'm not going into the details of what happened, but ultimately the welfare association was the highest bidder. So this consortium of these three welfare association was the successful resolution applicant. Are we clear on the facts? So this was about a construction company. Construction company, there were three resolution plans. Out of the three resolution plan, the plan of the consortium was approved. Now, Kotak Mahindra Bank and Kotak Mahindra Prime were two of the dissenting financial creditors. When the IA was filed for approval of the resolution plan, they filed their objections to this plan. Now, what was their objection? Because ultimately, this is the objection that has ultimately gone to the NCLAT, where NCLAT has not considered the objections to be valid and rejected them. So, first, let us try to understand what were the actual objections of these parties. The first objection was that, I'll just show. This was the objection. They said that, look, the resolution plan which is submitted by the consortium is not in compliance with 32. First, you have to understand that what was the date when this decision was passed. Are you with me? Because this judgment is like a huge 100-page judgment. So I'm not going into the details. I'll just explain it to you overall. Exactly, like I'm just going to explain in brief what the judgment of NCLT is about. But have you understood this particular facts?
Yes, madam.
Yes. Yes. So now let us try to understand that what were the objection which was raised by Kotak Mahindra Bank and Kotak Prime. Okay. So they said that, look, this plan which has been filed by the welfare association is not in compliance with the section 30, because under section 30 the amount is supposed to be payable to dissenting financial creditor who do not vote. We have said that we are objecting to the plan, so we should be paid as much as the liquidation value. And they said as per the liquidation value, as per the valuation report, what was the value for this particular park? Now, Kotak Mahindra Bank and Kotak Mahindra Prime had given loans, or their security interest was restricted to this Universal Business Park project. They had not given an overall, they had not taken a mortgage of the entire set of projects or anything. They were concerning only with this Universal Business Park project, over which they had a pari passu charge. So they said that look, liquidation value is 299. Therefore, the value of this particular ascribed to this particular park is 51 crores, and therefore our liquidation value should be considered as significant, and if we are dissenting, we should be paid that value. Okay, the resolution professional said that is not the case. He had disputed that. He said that is not the valuation. You cannot say that if the overall liquidation value is 255 crores, then my value will be the proportionate share. You cannot say that. They said, what was the resolution professional's answer? Resolution professional said that as per the resolution applicant, in the entire plan for Universal Business Park, the liquidation value is nil. Why? And we will go through that why in the NCLAD order. But right now, the resolution professional said that look at the resolution plan. In the resolution plan, liquidation value is nil. So the resolution plan gives you 3 crores for this Universal Business Park project. So your share, which has been given, is 3 crores. You are going to be paid 3 crores, which is more than the liquidation value of your asset, which is nil. So this entire discussion in this particular NCLT judgment and also in the NCLAD judgment is about what is the liquidation value of the assets of the corporate debtor, because there is a challenge to the valuation, and Kotak Mahindra and Kotak Prime have challenged this valuation which has been given to this particular project. Yes, so resolution professional has given this explanation. Resolution professional has calculated liquidation value for the financial creditor based on unsold area available for the project which have been financed. Secured financial creditors have not concurred with the view of the resolution professional. So valuation, why is valuation challenged? Because they say that look, there is this park called as Universal Business Park project. In this project, there is no unsold area, and therefore, when there is no unsold area, what is mortgaged? The value of mortgage when everything has been sold is nil, and therefore we have calculated liquidation value to be nil, and that is how they said that liquidation value is nil. We have given you 3 crore, that is enough. Whereas Kotak Mahindra Bank said that no, the valuation of the entire project is 299 crores. So the valuation of this Universal Business Park is 51 crores. So I should at least get 51 crores and not 3 crores, which you have claimed. So this was a dispute regarding the valuation which was given. Diwan Housing Finance also raised the same issue regarding valuation. But in the NCLAT, it is only Kotak Mahindra Bank which has gone in NCLAT. So we are not dealing with the objection raised by others. We will just go into the fact regarding what was the RP's solution. Just give me one. Let me see the. Let us just see what was the objections to the I which was raised. This is para 4. Para 11. Because without understanding that, the entire NCLAT judgment is very difficult to understand. Just hold on. Yes. So these were the objections which were raised by resolution professional to this I. So resolution professional said that why is Kotak Mahindra banks, whatever security they have in this universal business park, why have I considered the liquidation value of that particular thing to be nil? So he said that look, corporate debtor has a super built up area of 2 lakh in this universal business park. Out of that, conveyance deed have been executed with respect to 90 square feet, so this is not a subject matter of mortgage. Then he went further. So he said that TDS rights were there and value. Just 1 second. I'll just tell you. Hold on. I'll show it by way of enclad judgment. It is more simpler that way. Hold on. Yeah, there is a chart which they have done, which is very nicely prepared, which will give you an entire gist of the issue that has been raised in this particular matter. Yes. So this entire issue concerns Universal Business Park project. There was Kotak Mahindra Bank and Kotak Mahindra Prime had taken certain mortgages for securing certain loans which they have given. Now, those that particular what is that mortgage that they have taken is pertaining to one of the projects out of 6 7 project that Universal Buildwell has. So regarding other project, which was the Pavilion project, resolution plan provided that for Pavilion project, you can take your asset, whichever are your asset, you can take it away the way in section 52. A secured creditor can keep away from the resolution process and realize his security asset. Kotak Bank has a right to take those assets regarding Pavilion project away from the project and they can dispose it of the way they want. So Kotak Mahindra Bank had no objection with respect to the resolution plan to the extent it concerned the project of Pavilion. Now, when it comes to the resolution for this Universal Business Park project, they had an objection. Now, Universal Business Park project had a total sellable area of 2.15 square feet. Out of that, there was some other promoter who had certain share in this, which was 43. So the balance area which was available in Universal Park project was 1.72, out of which the company had already sold a conveyance and conveyed the property of 89 square feet. So Kotak Mahindra Bank said that look, this is what the RP has given. So the balance area is 89 square feet. So you should give me liquidation value which is equivalent to the price of this 89,000 square feet. This was the stand of Kotak Bank. What did the RP say? RP said that look, this 89,000, which is the area which I have shown you, this entire area is covered by a builder agreement, BBA. So there is a builder agreement. So this 89,000 square feet which is available is not legally transferable because this is not something which is a free saleable assets of the corporate debtor. So I cannot consider and give you liquidation value equivalent to 89,000 square feet. Though you have a mortgage, still this particular asset, there is a builder agreement concerning that, and therefore this value you will not be able to get as a part of the total sale, as a part of the liquidation value. Even if you have this security interest today, if you try to sell because of a agreement for this allottees, you will not be able to sell this property, and because you will not be able to sell this property, that's why the liquidation value is nil, and that is how they have mentioned. The appellant's case is rather builder agreement does not constitute a transfer or sale under the Transfer of Property Act, and therefore the legal title of that property still continues with the company, and therefore you should give me a liquidation value or that value equivalent to that 89,000. So court has finally decided, and said that look, this BBA, once it is signed, the builder agreement which is signed with the allottees, that creates a right in favor of allottees. There is this judgment of Bikaji Chatterjee, which is the judgment in the case of Amrapali, where they have said that when you have allotted, when there are real estate allottees, that particular part which has been allotted to certain allottees, that is not covered in a mortgage. Because if you see mortgage given to any banker, that contains a list of units sold. So list of units sold will include the detailed list of all the flats which have been sold. So therefore, if this has been mentioned and a builder's agreement has been entered, and this entire 89,000 square feet area, there is a builder's agreement concerning that, and there is an allotment concerning that, then this entire area is outside the perspective of this particular so if liquidation were to happen because of this Amrapali judgment, and because builders agreement is considered, this agreement initially executed in favor of home buyer to purchase may not create rights in the property in presentee. However, it will, on execution of the registered document, the title is going to be perfected, but the investment in project is only of the home buyers. In this case, as they have paid money invested in the project, it is for the courts to do a complete justice between parties and to protect this investment so made and the interest of the home buyers. So they said that as per this judgment of Bikaji Chatterjee, when there is a builders agreement, and when the entire area in this particular project park, universal business park, has been allotted by way of allotment to all these allottees, entire project is sold out. That means that today, as a mortgager, you will not be able to recover anything in the project, and that is the reason why your liquidation value is nil. And therefore the Supreme Court, the NCLAT finally decided that based on this judgment, we are finally deciding that your liquidation value, which has been considered as nil, is right, and therefore we are not going to interfere with this judgment which has approved the resolution plan. And that's how the plan which was given by the welfare association was validated, and they have agreed to go ahead with the resolution plan. So these were the three judgments. Two were regarding resolution plan. One was regarding Section 7 admission. So if you have any further questions regarding this, we can take it up, or else we can move on to the second part of our lecture series. Anu, I believe there are no other questions. We can move on to Nipun.
Yes, ma'am. Thank you so much for the session. 1 second. Yes, ma'am. Thank you so much for the session. It was very helpful. So now the next session will be
Thank
taken
you.
by Nipun Singhvi, sir. I'll briefly provide you the introduction of Nipun Singhvi, sir. He is a practicing advocate. His qualification includes FCA, CS, LLB, LLM, certified forensic IFRS bank auditor, qualified independent director. He has been member of the World Bank Insolvency Group on Train the Trainers jointly with IBBI and IPA of all the three institutes, which is ICAI, ICSI, and ICMAI. He has been appointed by NCLT for convening meetings as chairman in disputed cases of operation and mismanagement. He was also awarded by Divya Bhaskar, Dainik Bhaskar Group for excellent contribution in real estate justice 2021. He has delivered more than 1,600 lectures on various laws and across 70 cities. He is a regular faculty at various institutes. Sir, you may now start the session.
Thank you, Anuji, for such a detailed introduction. I don't think I'm worthy for it. And thank you, Prachi ji. I don't know, is it I think screen is being shared. Prachi ji, I think you will have to stop sharing the screen. Anuji, now am I audible?
Yes.
Some issue. So I will.
Nipun, are you facing any problem? Is my screen sharing still on?
No. Prachi ji, now the screen sharing has stopped. I am sharing my screen. Yes. I think now it is visible to all. Yes.
Yes,
Anuji
sir.
can- Okay. So it makes my job very easy as Prachi ji has already set the ball into rolling. And Anuji has given me 2 judgments to be taken today. So I will start with the Appu Hotels judgment, and it's a very interesting judgment. So my suggestion is that we will first go by what are the main points or the ratio descendi of the judgment. And then if time permits, then we can refer to the relevant paragraph if time permits. So the first one is the Appu Hotels judgment, and the second one I would be taking is the Moser Bear judgment. So first the Appu Hotel judgment, and I think many of you must have read the Appu Hotels judgment of NCLAT, which came last year. So I think some of the participants, I will just ask questions. What could be the learnings of the Appu Hotel judgment of NCLAT? Because now we will be discussing what Supreme Court held. What was the learnings of the NCLAT judgments? Any participant can tell me what was some new thing which came up because of NCLAT judgment. And I would love that you would respond. I'm also going to take queries side by side. So yes, friends, you can, anybody can volunteer. So Anuja, I think anybody can speak, no? Anybody can unmute and speak. So anybody, any participants? So we have a good number of participants. 96 is a very good number. So participants, can you tell me any one thing which was very important from Appu Hotel judgment of NCLAT? Anybody would like to tell me? No one. Okay. Okay. Yes, you can type it in the chat box also. Just want to see how many of you are responsive. Okay. So I'm not finding anyone. Mr. Murthy, you are there? Murthy ji. Okay. So then if nobody is volunteering, then let me start. So one very important thing which came up was, and it started from Vijay Jain judgment. So in Vijay Jain judgment, what was the crux? That the resolution plan copy should be shared to the suspended management also. That was one of the learnings from Vijay Kumar Jain judgment, famously called the Ruchi Soya judgment of Supreme Court. And one consequential thing which came from NCLAT judgment, and the question was whether valuation report can be shared with the promoters or not. So now you tell me what Appu Hotel NCLAT said. Can the valuation report be shared with the suspended board of management? So I am talking about the valuation report and not the valuation figure. not the figure of liquidation value and not the figure of fair value. I am talking about the complete valuation report. So anybody, what did Appu Hotels Enclave judgment say? So I'm here to get some answers from you. Yes, participants, somebody at least give me some answers. We have 96.
Can I?
Yes, please, please.
Actually, so far as valuation report is concerned, as per my understanding, it could be shared with a proper disclosure. NDA.
Okay, so we can share the valuation report with the suspended board of management or the suspended board of directors. Am I with you?
No. Suspended board of directors, not suspended board of directors. It is meant for COC.
Okay, so any participants who says that it cannot be shared with COC? Anybody? Yes, I got one volunteer. Okay, so Mr. Murthy is saying can be shared to COC. Mr. Rajkumar is also saying can be shared with COC, obviously with the confidentiality undertaking. And that's right. We can share it and there is no problem. Now the question, which is a sequitur to what Vijay Kumar Jain says, can we also share the valuation report with the suspended board of management? So answer given by Appu Hotels in Enclave judgment was, yes, it can be shared because when the resolution plan copy was to be given, the logic was that when they are participating in the COC, they must be aware and they should take part in the effective discussion. So that was the logic. And by the same logic, this valuation report should be given. And that was one of the learnings from the Appu Hotel judgment. And consequence to that, even one of my orders also came of Enclave because this Appu Hotel was Enclave Chennai. We got an order of Enclave Delhi also in one of my matters of care office equipment, where it was held that yes, valuation report can be given to suspended management, or provided that the confidentiality undertaking is there. So one of the learnings was, yes, valuation report should be given. So I'm just trying to understand the sequitur from Vijay Jain, that now we have come to a position where we are giving some room to the suspended management, even to participate in the meetings and even to facilitate valuation disclosure so that they can definitely come out with the resolution plan. And why I am discussing this point is that in the matter of Appu Hotels, this particular promoter group had given a resolution plan. And what happened in the Supreme Court, that we will discuss, because there are many facets to this particular judgment. And I have tried to analyze the judgment into some parts. So the resolution plan was given by the promoters as well as by the promoters through a trust. So I'm just going to discuss point by point what Supreme Court held and when the NCLAT judgment was confirmed or reversed on that particular point. So first issue is whether somebody can, through a trust, give a resolution plan. So the view taken by Supreme Court, I will first tell what Supreme Court said, that you cannot do a beneficial business. So if you are a trustee of a trust and you are giving a resolution plan, which is ultimately going to benefit you in your personal capacity, it is prohibited. So if you are part of a trust as a trustee and you give a resolution plan, it is not legal as far as Section 88 of the Trust Act is concerned. And even otherwise, if you are a beneficiary in your personal capacity, then no, you cannot give the resolution plan. So this is one of the first learning or the first issue, whether a trust can give a resolution plan or not, if one of the trustees is interested in the resolution plan. So here the promoter was the trustee. Now, the second issue, and there are multiple things in one story and one issue, but I am only focusing on the legal part. I am not going on to the facts, what happened, when happened, but the crux of that particular issue. So the second issue is whether Form G, suppose there is some technical issue and we are not able to upload the Form G on IBBI website, or maybe there is a delay in uploading, whether that will prove to be fatal to the whole process. So in this particular case, during the time of COVID, actually it happened that the Form G was not being uploaded on the IBBI website because of some technical issues. RP took it up with IBBI also, had some communication and evidence to show that it could not be uploaded. However, the paper publication was done in the newspaper as per law. Some 13 EOI also were received. So therefore, court, on observing that there are substantial evidence and we are satisfied that the work done by RP does not suffer from any illegality and probably the irregularity is justifiable. Therefore, with regard to Form G, we are not going to accept the technical irregularities and it will not prove to be fatal. So this is a very important learning which comes from the Supreme Court judgment, that some of the procedural aspects have now been held to be directory and they cannot be proven to be fatal. And in fact, recently another order of NCLAT came in the matter of Syntax Industries, wherein also the similar issue was raised, that there was some issue with regard to one of the claimant or proper communication or proper redressal of the grievance of an operational creditor was not done. And NCLAT held that even if there is some procedural irregularity or maybe some conduct issues of the RP with regard to a particular claimant, that will not prove to be fatal to the CIRP process as a whole. And if the resolution plan is approved, it cannot be set aside or maybe challenged on this particular ground. And I think one more judgment came on the similar ground, wherein one group of the operational creditors also challenged a resolution plan, saying that we were not called and we did not participate in the COC. And the view taken by NCLAT was that even if operational creditors come in the COC meeting, they do not have a voting rights. Yes, the conduct can be seen of the RP, but that will not prove to be fatal to the approval of a resolution plan. Yes, in that case, I think there was some 1 lakh cost also imposed on the RP. Be that as it may, it will not prove to be fatal for the resolution plan. So broadly, the consensus is if there are some procedural irregularities, now courts are ignoring them and not taking them as seriously as if that particular action would make the complete process illegal or maybe fatal. Another aspect.
Sir, one
Yes,
more
please,
point
please,
to be
please.
clear. Can I, sir?
Yes,
With your
please.
permission?
Please, please.
Sir, like, this valuation report, I mean, now it is settled that, okay, it could be shared with COC, I mean, the suspended board of directors. So, isn't it? So what about resolution plan? That also needs to be, I mean, shared with, because many a times it is happening in the, like, open court also, like when suspended board of directors, they represent themselves asking for the copy of resolution plan. I mean, they have been denied. What is the correct
so I
position of
started,
the
Rajkumarji, I started with this, that as per Vijay Kumar Jain judgment, resolution plan copy has to be given. So there is
Okay.
no ambiguity on this particular point. The
Okay.
sequitur now comes that even valuation report can be shared.
Right, sir.
So Vijay Kumar Jain, I think it's almost more than 3 years we are living with that judgment. Vijay Kumar Jain versus Standard Chartered Bank, Supreme Court, wherein it was held that the resolution plan copy has to be provided to the suspended board of directors. So that is a settled law. There is no argument on that.
Thank you, sir.
So another issue which was raised with regard to the resolution applicant was section 164. So see, section 164 is a disqualification section, and probably most of the participants would be aware that there could be some of the actions like I have not filed my returns, then my company would get struck off, I would be disqualified. If I am convicted for an offense of more than 6 months, I am disqualified to be a director. Or if I am a director in a company which is struck off, then also I become disqualified to be a director in any other company. So all those issues are there in section 164. Now, the allegation or the argument was that the resolution applicant was also a director in a company which, according to the evidence with them, did not file return, and therefore he was disqualified for 164, and probably it was struck off some aviation company. So court went to the extent of seeing that is there any judicial order or an order that he is disqualified. So the argument of the appellant was, and the resolution applicant was, that the DIN was active and therefore he is not disqualified. So court accepted this argument and said that if the DIN is active, then that person will not be considered to be disqualified. He will be considered to be qualified until and unless there is an order of disqualification. So in abstract or in theoretical sense, if he is disqualified, it is not termed as disqualified as far as 29A is concerned. So I think this is an important aspect for us, because most of the IPs, I know that they do due diligence and see the 29A. So this gives some of the light that even if somebody is a director in a company, which have probably disqualified in theoretical sense, but if his DIN is not blocked, then that person would be qualified to give the resolution plan. So 164 point, I probably understand that all of you have got. This has to be seen vis-a-vis 29A. Second point, and probably very interesting point, is section 166. So 166, as we all know, duties of directors under Companies Act. And if somebody is not doing something in the interest of the company, he is violating his duties. He is breaching his duties. Now, in this particular case, the plan given by the resolution applicant was that he was proposing to construct a hospital on the land of the corporate debtor. And he already was a director in a company where he was running a hospital. So now the question came that if I am entering into a competitive business, whether I would be disqualified because of attraction of section 166. It's a very interesting issue where the court accepted the argument of disqualification and said that the resolution applicant would be disqualified if he is proposing to enter into a competitive business. So I think this 166, we have very less jurisprudence. And I remember only one of the Delhi High Court judgment on 166, wherein it was held that if competitive business was there, that case was of a husband and wife. If I could remember the name, it was some Neetu Singh versus something, wherein the wife and the husband, they both were director, and then wife opened another competitive business in another company, and that was held to be a competitive business against the interest of the company, and therefore a disqualification got attracted. So technically speaking, if somebody is entering into a competitive business, he would be disqualified. Now, in my opinion, and the judgment does not say so, but it is my opinion, that suppose I am entering into a competitive business, I need to have a authority or maybe a disclosure to the existing company that I am entering into a competitive business, and that existing company should not prohibit that competitive business, and it should practically allow me to have a seat in the competitive business. So now this has to be seen that there should not be a competitive business which is against the interest of the existing company in which I am a director. So this is something new, and this has to be now seen. And therefore now onus again has come on us as an IP to see that this does not get attracted and the person doesn't become disqualified under 29A. Now, with the valuation point, which I was saying, and why I was discussing, because I had faced a similar issue of valuation by the promoters. So now here, the points raised by NCLAT on the allegations of promoters and all that, whether valuation was done correctly or not, it was the re-evaluation, and then again valuation was done on the instance of COC by the RP. So all the exercise of valuation 1 or valuation 2 or revaluation done on the instance of COC or on the basis of allegation was correct or not. So Supreme Court said that valuation should be done to the satisfaction of COC. So if the valuation is done to the satisfaction of COC, there is no problem. It's fine. So ultimately, court went by the supremacy of the COC's commercial wisdom and held that if the valuation is done to the satisfaction of the COC, then nothing doing, it cannot be now objected, and therefore they set aside the NCLAT comments with regard to valuation. So again, a procedural issue to the satisfaction of COC. If the COC is okay, then nothing, no objections can be there. So in this particular judgment, what I understand, Supreme Court has given some parameters on which the process can be understood to be fatal, and some of the points on which procedure will not affect the CIRP process. Then one of the interesting fact, and this is very important for all of us as IPs, that the fee of the RP was increased, some 1.5 lakh to 2.5 lakh, that fee was increased. And NCLAT commented on the RP that the increase in the fee gives an indication that there was something, some incentive or some inducement to the RP to press a particular resolution plan. So increase in fee was considered to be an inducement to the RP. So there was a negative comment on the functioning of the RP. And this particular comment has been set aside by the Supreme Court, saying that increase in fee cannot be correlated that what plan has to be filed before NCLT, because ultimately COC are aware. Ultimately COC are aware what is plan A, what is plan B, what is plan C. So such comments are not desirable, and they set aside the comments against the RP. So what we learn from this, and I think practical utility of this could be that suppose the process is running too far, because in this matter, there were appeals, there were remand, there were again appeals, there was some objection, extension, exclusion, and all this happened. So if the COC are of the view that the fee of the RP can be increased, so there is no barring. They can increase it. So ultimately, it is the commercial wisdom of COC that will prevail, number one. Number two, if a plan provides for a better fee or for better realization, then there is no problem in giving more fee to the RP. So I think this is a welcome step, that fee of RP should not be treated as an inducement to press a particular plan. So this is something which is good sign that even courts are acknowledging that we are working day and night, and therefore increase in fee should not be treated as an inducement for pushing a particular resolution plan. Now, second is an interesting issue with regard to related party. So here we will talk some legal sections. Normally, if we read the section 53 gives us the waterfall where we are paying to the financial creditors, secured financial creditors, then unsecured financial creditors, and then operational creditors. Now, the question which comes is, when we are paying to the financial creditors, normally we are paying a fixed amount to a class of financial creditors. Now we know that there are two types of financial creditors. So one category is related and one category is unrelated. Now unrelated would be normally the outside bankers, and related party mostly would be the group of maybe promoters or their friends or relatives, somebody like this. Now, the question which came before the court for consideration, and it's very interesting because Anklet said that the related and unrelated party, there is no distinction. So whatever amount I am paying to the unrelated financial creditors, same thing I have to pay to related financial creditors, because the law does not differentiate as far as section 53 is concerned. However, if you read the resolution plan regulations, it says you are paying dissenting financial creditors as much as the liquidation value. You can obviously pay over and above the liquidation value, but that is the bare minimum which you will have to pay to the dissenting financial creditors. But as far as COC voting is concerned, related party financial creditors are not permitted to vote in the COC. So there is an anomaly. Anomaly is like this: the related financial creditors do not participate in the voting. However, an interpretation was given that as far as section 53 is concerned, they are considered to be on same parity or maybe equal in position as placed to the unrelated financial creditors. Now, Anklet was of the view that the payment has to be done to them also at par with the other financial creditors. So related, unrelated, no differentiation, and therefore equal payment as per NCLAT judgment. Supreme Court has reversed the judgment. on this aspect. And what Supreme Court says that the law makers are aware why they have prohibited the related party from being entering the COC is that the related parties are not given rights. So if they are not given rights, they do not form part of the decision making. It is ultimately the commercial wisdom of COC. If they do not want to pay to the related FC, they can very well not pay the related financial creditors. So this is a very important point wherein because of this Apu Hotel judgment previously, most of the plans wherein the related party financial creditors are there, they were coming to the court and objecting to the payment. And in fact, I have seen cases where they were objecting that it is against the law, 30 subsection 2 clause E, because it's in contravention and we are equal, and they were arguing Article 14, we should be paid equally. Now, this particular point is being put to rest by Supreme Court, no payment to related financial creditors as far as the interpretation of 53 is concerned. Now, probably some of the participants will be asking me, sir, then can we pay to the related FCs? Yes, if the resolution applicant wants, he can pay. There is no prohibition on payment, but there is no mandation on payment. So I suppose I am clear. It's not mandatory to pay them, but again, if the resolution applicant wants, he can definitely make the payment to them also. They are not, I would say, belittled with their rights, but yes, they are not given an equal status to that of unrelated financial creditors. Till this, any query of any of the participants, or you can put it in the chat box, or you can unmute and ask. So then comes probably another issue with regard to settlement offer by the promoter. So in this case, probably when you will read, there is much of a factual matrix that every time when the plan was about to come or plan had come, the promoters would come out with the settlement proposal or maybe a offer to the financial creditors. And this happened, I think, almost 3 times during the process, and that complete details are there in the judgment. Now, when the last time the plan was to be considered by the COC, before the meeting was scheduled, just 2 hours before that, a settlement offer was made by the promoters. And some few of the COC members were of the view that it need not be considered in the COC because they don't want to give any assent or even consider it in the discussion that we have received a settlement offer. They were of the view they will not discuss about it, and therefore they will proceed with the resolution plan, which is already there on the table. So the allegation was that the resolution plan, or sorry, the offer from the promoters was not put before the COC, and COC was only put before this resolution plan was only put before COC. So resolution plan was different and settlement offer was different, and settlement offer was not considered by the COC. And therefore settlement offer...
Sir, could you please repeat the
Yes,
past
please.
two para? Could you just repeat for better understanding?
Okay.
You just narrated. Yeah.
So I'll just read the factual matrix when we come on to the judgment, but just for the understanding that whenever the plan was about to be considered, the promoters have every time come out with the settlement offer or with the plan. So court had narrated those instances during the process. So once they came at the last moment, again, the second time they came at the last moment, and this kept on happening. So the last instance, which was before Supreme Court, the discussion was like this: when the plan was to be discussed in COC, let's say at 3 o'clock. So just 2 hours before, let's say 1 o'clock, they gave a offer, settlement offer. They mailed it to the COC. And their allegation before the Supreme Court was that this was not considered. So one of the allegation was that the plan was not, this settlement offer was not considered, and only a previously decided resolution plan was discussed in the COC. So this particular process is illegal. That was the allegation. So court said that we are, and in fact, they have used very harsh words, that the promoters have every time played some trick and brought out some or the other offer. And every time they come out with an offer, it is not sustained because sometimes the person who is backing them for the funds withdraws the offer. So
Okay.
they in a sense were not very happy with the conduct of the promoters with regard to giving offers at the 11th hour. In short, the offer which was given at the 11th hour was not appreciated by the court. And further, the court went on to say that even otherwise, for 12A to be triggered, there are two instances. So let us understand what 12A says. So 12A has two limbs, pre-COC and post-COC. Pre-COC, only the petitioner and the RP and the suspended management sit together and withdraws. But once the COC is formed, then it is the process where 90% of COC approval has to be there. If 90% of them do not agree, then even otherwise the 12A cannot be triggered. So even when the COC members are aware of a settlement offer and they don't want to deliberate on that particular offer, it cannot pass through the muster of 90%. So in short, what the court meant was that if the COC members are not inclined to discuss your 12A, and even otherwise the statutory mandate is of 90%, then it makes no sense of making this allegation that it was not discussed or deliberated. They were well aware about the settlement proposal. So this is how the settlement offer by the promoters has been discussed by the Supreme Court. So I now open it for questions with regard to what we have discussed, because I have in very brief discussed the ratio descendi of the relevant issues which has been taken by Supreme Court. So I think any queries on this?
Sir,
Yes.
what about sharing of information memorandum with the suspended board of directors at the meeting where this IM is going to be placed? It is still, I mean,
So there is no prohibition, sir. Even otherwise, sir, information memorandum is going to be discussed in the meeting.
mhm.
I don't find any prohibition.
So that means the suspended board of directors can remain present throughout the meeting.
Sir, even otherwise, sir, if 29A relaxation is there, they can even give the resolution plan.
Mhm.
So I don't know why, means what is the exact point you are going to ask?
No, same thing, like because I am like it is also one of the very secretive document.
See, now even the valuation report has to be given.
Yeah,
So
yeah.
what
Now
is
it
the
is at par with, like even said, valuation report and resolution plan could be shared with a suspended board.
Now
Why
the
not
only
I?
point is, now the only point which I could understand is that confidentiality undertaking, if it is taken, everything can be shared, whether it is COC or suspended management, because of these judgments now. Yes, if we read the bare law, it was not very much clear. But yes,
Okay.
because of this, I think now it has opened another floodgate.
Hmm.
So any other queries, friends? I was seeing so many IPs, but no queries. Okay. So then let us then go to the judgment reading. So it's a very nicely they have made index in the judgment also. Just open the judgment for the sake of everybody. So this is the judgment. So this is the Appu Hotel judgment. It's called M.K. Raja Gopal versus Dr. Parisami Pallani. And if you see the judgment, they have given a brief outline and they have also made subtopics. And you can see here they have enumerated all the issues. Though I have all captured all the issues. So you can see the valuation, publication of Form G, 164 2B, Section 88 of Trust Act, 166(4) of Companies Act, revision of plan, relevance of resolution professional fee, related party payment, NCLAT finding with regard to settlement offer, and subsequent event. So if you see part A, this point A to point G, what has happened? I'll just detail it. So what is not approved? So there is a judgment of NCLAT. Supreme Court has not approved A, B, C1, D2, E and F. So these 6 points they have reversed. What they have confirmed is C2, C3 and D1. So basically, if I summarize it, whether valuation was done correctly, Supreme Court has said confirm if it is to the satisfaction of COC. Whether publication of Form G was done correctly, answer is yes, because there was substantial evidence and therefore they have done correctly by placing it in the newspaper, even though there was some technical glitch on the website of IBBI. Then section 164 2B, whether disqualification of director will automatically come even if the DIN is active. So answer is if the DIN is active, then they will not be disqualified. Then section 88 of Trust Act, if the resolution applicant, who is the promoter, is giving the resolution plan through a trust, it is for his benefit, and therefore section 88 will come into play and he would get disqualified. Now, section 166(4), if he is getting into a competitive business, as I told you, of running the hospital, then he is disqualified. Revision of resolution plan after approval by COC. So this is very important that once like COC has approved a plan and thereafter some changes are made and then it is filed to NCLT. So those changes have never been approved by the COC. Whether this is considered to be correct? So answer is this is incorrect. Any modification or any change in the resolution plan has to be put before COC and then only it can be submitted to NCLT. And in fact, I assume that most of the participants here would also have seen, like most of the NCLTs are now insisting of compliance of the resolution plan, let's say to the rainbow paper judgment. So they are again sending it back to COC. So point is, if there any change or modification in the resolution plan, which is approved by the COC, subsequent to that, there is any change, it has to again go back to the COC, and only when COC confirms it, it will go to the NCLT. So in this particular case, there were some modifications which were not put before the COC for consideration. Therefore, Supreme Court was of the view that any modification or change should be put before COC and COC should consent to it. Point D2, I have told you that increase of fee of RP was done. So an allegation or maybe an interpretation was taken by the NCLAT that fee has been increased of the RP to push resolution plan. So that argument was rejected by Supreme Court, saying that just because the fee of RP is increased, that does not mean that they want to push a particular resolution plan. Point E, very interestingly, the related party point, which was reversed, the view of NCLAT was reversed. Related party who are financial creditors do not have an overwhelming right like other financial creditors to get equal payment. And the legislature has in its conscience kept them outside the voting rights of COC. And then settlement offer of promoters, I told you it was very fishy. Every time they came out with the proposal of the to be settled with the financial creditors, and again that proposal was withdrawn or rejected. So that was a point where this particular settlement offers by the promoters was not considered to be in good taste by the court. However, now if we go to the findings, very interestingly, what has happened is, if we just see the findings, so I just told you what, this is the conclusion. These are the points which have been affirmed. So C2, C3 and D1 have been affirmed. However, what they are saying, question of dealing with fresh settlement proposal of the promoter as approved by COC in 19th meeting dated so and so, after receiving fresh resolution plan, is left open for consideration by adjudicating authority, who shall be expected to deal with the matter while keeping in applicable law. So point is that the settlement offer which was given by the promoters was pending with the NCLT, and fresh resolution plan, whether those resolution plans should be considered or not, is also pending with the NCLT. So Supreme Court has left it open to the NCLT to decide on the call whether the settlement proposal has to be accepted if the COC is standing with the promoters, or new fresh resolution plan should be taken, that the process to be again restarted from the point of time when it was concluded. So the both the things are there which have been left open for the consideration of NCLT. So if you see the complete judgment, if you think that this judgment is a final end to the process of CIRP of Apo Hotels, answer is no. But some of the legal issues which have been bone of contention between promoters, COC, and the RP have been put an end to. And these points already I have told you from A, B, C, D, E, F. So all these points are there. So this is long and short of this particular judgment. I think there are some queries. Okay. During the process of liquidation, can a company be sold as a going concern without doing e-auction? So I think though it is not connected with this judgment, still I will deal with it. So Sonu ji, yes, you can sell the company as a going concern and you can also sell business as a going concern. Now the regulation provides that the going concern sale has to be done exclusively on the first auction. So that first auction has to be of going concern sale. Subsequent auction, obviously other multiple options you have under the regulation 32, you can go with it. But auction has to be there. There is no escape from doing an e-auction. Okay. Okay, so Mr. Rajat has asked a question, and very interesting question, that we asked for past experience of resolution applicant. Don't you think it is a conflict with section 166? So again, I am sharing my view and my interpretation of this finding of Supreme Court with regard to section 166. See, I think we will just open 166 only. That will put to rest what exactly section 166 says. In a moment, I am just opening 166. I'm just sharing you what is exactly in 166. So this is the section 166 subsection 4. So duties of director. A director of a company shall not involve a situation in which he may have a direct or indirect interest that conflicts or possibly may conflict with the interest of the company. So this is what section 166 is. And I think I'll just take you to the relevant part of section 166 of the findings of the Supreme Court. So this is point number C3, which is confirmed of what NCLAT has held, confirmed by the Supreme Court. The submission of resolution plan by the resolution applicant was directly hit by section 88 of Trust Act and could not have been approved. In this view of the matter, no other aspect requires consideration regarding eligibility. However, point number C3, for determination in view of the submission made in this case regard to ineligibility of RA, it appears appropriate to deal with this aspect. The status of the appellant, who is the RA, is a managing director of another company, which is MGM Healthcare Private Limited, is not of any dispute. So he is holding the position of MD in another company, which is a healthcare company. The particular of this company and projection for taking this company forward had been stated extensively by the RA in his profile submitted with the plan. As per the resolution plan, the appellant RA had proposed to convert the Coimbatore property of the CD into a hospital. So this CD is the corporate debtor. The said MGM Healthcare is also said to be a super specialty hospital, and the company is said to be looking forward to set up new hospital and aspires to be a leading hospital chain in India. In the background of these facts, section 164 of the Companies Act prohibits a director of a company from involving in a situation which may have direct or indirect conflict with the interest of the company. Now, status of RA as MD of this MGM Healthcare company, he is dealing with the property of the corporate debtor and converting the same into a hospital cannot be said to be having impact on the activity. So that is what the argument was. A direct conflict of interest being writ large on the face of it, it cannot be said that prohibition does not operate and plan does not stand in contravention. For this reason too, the RA could not have been accepted as an eligible applicant. So the crux of this particular issue is that if the director is involving in a position which is conflicting with his existing business, then sorry, you are breaching the law and therefore you are ineligible. Now, my view, and again, I am telling this is my view, that suppose I am, let's say, I am Reliance Jio, assuming for the timing, I am into telecom sector. And now I want to acquire, let's say, Aircel or Reliance Communication. So obviously, same line of business, I would like to acquire it. Now, the point is, who is the RA? Am I the RA in my personal capacity or I am making my company as RA? So in my view, if my company is an RA, there is no conflict. So this argument will not be applicable. Now, let's say I am buying in my personal capacity, probably Aircel. Can I buy it? It will be conflicting with my position of, let's say, Reliance Jio. Now, this is a conflict which they are talking about. And in my view, a possible solution could be, and again, it's my view, a possible solution could be the existing company in which I am holding the position of an MD, in this case, this MGM Healthcare. Either they say that we have no issues, you can proceed and there is no conflict of interest. That could be one of the point. Or the company itself in which I am already MD, that company becomes a bidder for this company. Because tomorrow nobody knows, we can also acquire that company, we can do mergers with that. Many of the companies we know under resolution plan, the same line of business, they acquire another company. We have many companies in the same line of business expanding by acquiring the companies under IBC. So this is all possible. So this is my view. Okay. Can we go again for going the same? Okay, so I think Mr. Murthy and Mr. Sonu have asked again a question with regard to that going concern. So I think, sir, we can discuss it on one-to-one basis. Let us post our attention to this particular order. You can talk to me one-on-one.
Just a question.
Another question is there. Just 1 minute, Mr. Sudhir. If
Yes.
one resolution plan is approved with 90% voting and submitted to NCLT, another RA is offering more, can we accept? So, Mr. Sudhakar, my answer to this query would be, if your CIRP time is there, and if somebody is coming with the before the COC and COC is allowing, definitely you can consider. Otherwise, when the plan is approved by the COC and put before the NCLT, neither COC nor RA can withdraw the plan. This is already there in IBC Singapore judgment of Supreme Court. So that cannot be withdrawn. COC and RA both cannot go back on the plan. However, nowadays, if the COC makes a request to the NCLT, they can definitely send, or some legal issue like rainbow paper compliances come, then obviously NCLT will ask the COC to reconsider. So those legal issues, obviously it can come back. Or if there is CIRP time or there is possible exclusion or inclusion, then possible that situation might arise. Plain simple, it won't arise. Yes, Mr. Sudhir, your query, please.
No, sir, my simple question is that if I am an influential director, company may allow me to go for a bid in the personal capacity.
Yes.
Is it fine?
Yes, in my view, it is fine. Because we know many of the people having the same set of skills are on the board of director of different companies. It is possible. If my company is not having any problem that I go and acquire some another company, then it is fine. And if my company is also together with me applying for a resolution applicant, that is also fine. The question will only when there is a competitive disadvantage to somebody.
Fine.
But this is very interesting. And I think times to come, this section 166 will be argued in the courts. Very interesting issue. So I think no other further queries. So now let us see Moser Bear judgment. And I must tell you very frankly that most of the participants in another lecture also where I went, most of them were looking to get answers with regard to maybe ESI, PF, gratuity, all these issues which have arisen after the Jet Airways judgment, that when the resolution plan is there and resolution applicant is coming, whether these benefits will have to be paid or not. And the Jet Airways says you will have to pay it. And NCLAT said it and Supreme Court confirmed it. Now that issue has got spiraled and somebody told me that people are having a view of Moser-Bear judgment as if it is saying something else from what Jet Airways has been interpreted. And again, I must tell you all, we will read the Moser-Bear judgment and hardly there are 4 or 5 paragraphs in the complete judgment which runs into 72 pages. But according to me, there are hardly 6-7 paragraphs which are important. But the long and short of this particular Moser-Bear order is, it says nothing about the retirement benefits of employees. The judgment is squarely on a constitutional validity of IBC versus Companies Act. It has nothing to do with retirement benefits. It only talks about whether IBC waterfall is correct vis-a-vis Companies Act winding up provision. So I am telling you this at the outset because after reading the judgment, you will come to know that there is no solution to the problem which has been arisen by the Jet Airways judgment. I'm just opening the relevant paragraph. I'll just take you to the relevant paragraph. And in fact, this particular judgment, wherein Mr. Vishwanathan was the amicus curiae, today he is now elevated to Supreme Court as judge. So it becomes very much important. So I'm just taking you quickly through some of the relevant paragraphs, and that's all. Nothing beyond it. So basically, Moser-Bear judgment, what is the challenge in the Moser-Bear judgment? So I'm just reading the challenge. So there was a writ petition by a union which said that strike down section 327 subsection 7 of the Companies Act as arbitrary and violative of Article 21 of the Constitution. Petitioners sought for appropriate direction so as to leave the statutory claim of the workmen dues out of the purview of waterfall mechanism under section 53 as per section 327, 326 of the Companies Act shall not be applicable in the event of liquidation. These provide preferential payment in winding up provisions of the Companies Act. In view of the introduction of IBC, distribution is to be as per section 53. At this stage, it is required to be noted that IBC was enacted on 28 May 2016 and section 53 we all know, so I am not reading it. In view of the enactment of IBC and section 53, it is necessitated to amend the Companies Act 2013 as per section 326 and 327. It shall not be applicable in the event of liquidation. And therefore, in the event of liquidation under IBC, it seems that there may not be two different provisions with respect to winding up or liquidation, and therefore exclude 326 and 327 of the Companies Act, which cannot be said to be arbitrary. Now, what they're saying is that 326 and 327 say something else, section 53 says something else, therefore there should be a line where they both meet, and therefore they should be put in one line, one premise. They say that virus of section 327 is challenged to be applicable in case of liquidation under IBC, meaning thereby in case of liquidation, the provisions of section 53 and other provisions shall be applicable as the company is ordered to be liquidated or wound up under the provisions of IBC. Therefore, under the earlier regime, in case of winding up, the dues of workmen may have pari passu with that of secured creditor. The petitioner cannot claim the same benefit in case of winding up. The party shall be governed by the provisions of IBC in case of liquidation. So I'm just taking you to the relevant paragraph because this is nothing but just their submissions. The relevant para is para number 9. I'm just going to take you to the para number 9. So this is para number 9. And here the important part is As elucidated above, the Companies Act 2013 does not deal with insolvency and bankruptcy when the companies are unable to pay their debts, or aspects relating to revival and rehabilitation of companies and their winding up if revival and rehabilitation is not possible. In principle, it cannot be doubted that cases of revival or winding up of the company on the ground of insolvency and inability to pay debts are different from cases of wound up under Section 271. The two situations are not identical. Under Section 271, even a running and a financially sound company can also be wound up. The reasons and grounds of winding up are completely different, vastly different from reasons and grounds for revival and rehabilitation under the code. The two enactments deal with two distinct situations, and in our opinion, they cannot be equated or they cannot be examined under Article 14 of the Constitution of India. So point is, they are saying under Companies Act, for winding up, there are different grounds, and for IBC, there are different grounds. Inability to pay debt because of financial trouble under IBC is different from winding up, where even a financially sound company can be wound up if the shareholders decide or creditors decide, or if some of the article of association say so. So those grounds are enumerated under Section 271. So what they are saying is 271 and IBC both operate in different realms. They cannot be equated. Then they say in case of insolvent companies, for the sake of revival, including secured creditors, central government and state government, they are required to make sacrifice. The workmen also have a stake and benefit from the revival, and therefore, unless it is found that sacrifice envisaged for the workmen, which certainly have a separate class, are onerous and burdensome, so as to be manifestly unjust and arbitrary, we will not set aside the legislation solely on the ground that some or marginal sacrifice is to be made by the worker. Now see, this is very important. They are saying just because workers are having problem, we will not set aside the enactment. We also reject the argument of Article 14, also reject the argument of Article 21. We must word by word examine the waterfall mechanism, where the company is wound up in terms of clause A to E of 271 and the rights of workers of the insolvent company. You see, entirely different. So this is very important. They say both the grounds and situations in the context are entirely different. So what they are trying to do is, this was challenged on the ground that the Companies Act and IBC have created a situation where workers are at a disadvantageous stage. And they have rejected the challenge of 326, 327 vis-a-vis 53. So in short, whatever is there in the 53, that is being upheld. Now, if you are asking me the question, sir, whether there is any finding with regard to workers and employee dues, or maybe their other benefits like provident fund, pension fund, or gratuity, sorry, this is not discussed in this particular judgment. And I just take you to the conclusion part. In view of the above reasons, 327 and 326 of the Companies Act shall not be applicable in the event of liquidation under IBC, which was necessitated in view of the enactment of IBC, and it applies with respect to liquidation of companies under IBC. 327 cannot be said to be arbitrary. In case of liquidation of company under IBC, the distribution of assets shall be made as per Section 53 of the IBC, subject to Section 36(4) of IBC in case of liquidation of company. So we all know what is 36 subsection 4. That is what the finding of liquidation estate is. So the judgment of Jet Airways or previous judgment, which says that, let's say there was some provident fund kept with the company of the employees. So that is something which is outside the liquidation estate. So that is, I would say, super priority even above the Section 53. So they are recognizing that 36(4). And they are also saying the challenge to these waterfall and 326, 327 is rejected. And ultimately the writ petition is dismissed. So even if you ask me, this judgment is of actually no help as far as IBC is concerned. It was more of a challenge to 326, 327 of the Companies Act, which shows the winding up provisions and all. So I'll leave this Moser-Bear judgment at this because I don't think so. It is very much important. So now if you have any queries, we can definitely discuss. And if you have any doubt in the two judgments discussed, I would be happy to take them. Some of the Q&A were there. Okay. So first I'm asking the participants, is there anything else we would like to discuss? And if time permits, then we will take the other queries, which though were not directly related to the judgment, but since participants have asked, I would like to answer them. Okay. So I am supposing that there are no queries, then I will just answer what Mr. Murthy has asked. So Mr. Murthy, I think your query was, if there were two auctions earlier with regard to going concern, plant, machinery, and land and building, only plant and machinery was sold and now land and building is left. Can we again go for going concern as one of the options and land and building as second option? So, sir, there is recently a judgment of NCLT Delhi, wherein the view that has been taken is that though the regulation says first auction will have exclusively going concern sale, but it does not prohibit going concern sale to be there in subsequent auctions. So the interpretation is that suppose in first auction, I am putting going concern sale, and suppose that fails. So in second auction, can I put going concern sale plus maybe individual parcel or individual asset? Answer is yes. So subsequent auctions can be coupled with going concern, but the first auction cannot be coupled with selling of individual assets. It has to be only for going concern. That is what the recent amendment is.
Sir, can you just give the case law, sir? You're referring to NCLT New Delhi.
Yes, it is decided by Justice Bharadwaj. I'll just see if I could get the citation. It's a very recent order.
Okay, sir.
I'll just try to find it out and I will share it with you.
And one more thing, the reserve price relationship. What is the reserve price relationship? Going concern reserve price vis-a-vis the other assets which are left over. I mean, generally going concern reserve price will be little high.
Correct.
What is the sanctity for it? Instead, if it is the other way, is there any harm?
So, sir, can you give me example what you are trying to achieve?
So, for example, if you say that in a going concern, if you put the one of the option as a going concern, suppose the reserve price is say 150 crores.
Okay.
In the second option, if you are trying to sell only the whatever is left or land and building, if the reserve price is say coming to 105 crores.
Okay.
So how does it really affect it?
So, sir, it is always there. If you see any auction notice, going concern reserve price will always be higher than the individual assets being sold.
Yes.
And then, sir, again, even under going concern, if you see the regulation, there are two types of going concern. One is going concern of CD as a whole, and another is going concern of business. So nowadays, I have seen such type of auctions being taking place. Let's say a company has steel business and plastic business. So there are two businesses. Now, let's say one business is running and that can be sold. So they are selling one business. Obviously, you have to separate the assets and liabilities with regard to that business, but it is getting sold like this now.
Understood.
So, okay. Sonuji, during the process of liquidation, can a company be sold as a going concern without doing e-auction only? See, let us and just open the regulation. Let us see the regulation. Just open the liquidation regulation.
I don't think it is possible, sir. Like I've seen the regulation recently. Okay.
So let us see.
इसी में है।
So I'll just her query is very interesting. Special hearing. Just open the relevant part, just 1 minute here. So I think this is the regulation. Liquidator may sell the assets of the corporate debtor under clause E of clause 32 exclusively only at the first auction. So I think Sonuji is also here, no? Sonuji, you can unmute.
Yes, sir. Actually, you want to know that if there is no stakeholder in the company,
No,
and company stakeholder is not there, but we got one application from one person that we want to buy this company as a going concern, and we have referred this matter to NCLT. NCLT was saying that you do one publication in the newspaper that we got this kind of application from one prospective buyer. So we have done this, but in my opinion, actually we have to do this by e-auction. But my advocate is saying that we can sell it as per this publication only. So I need the expert opinion that can we go with this or not?
So let us see what you are trying to do. See, can you see it on the screen? I just opened.
Yes, sir.
Liquidator may sell the assets of the CD by means of a private sale in the manner specified in Schedule 1 when. So I think either you fall.
I think point number D, that prior permission of the adjudicating authority has been obtained.
See what I understand from your case. If you see clause C, asset is sold at a price higher than the reserve price of a failed auction. So is there any failed auction in your case?
No, sir. There were no assets in the company. So how can I put it in auction?
So how somebody is then going to buy as a going concern?
Because this is a listed company, so he want to buy this company.
Okay, so basically you are saying it's a going concern, but there are no stakeholders. Am I right?
Yes, yes.
So who will get the money if there are no stakeholders?
So money is only simple. He has given a offer only for ₹2 lakhs, and my liquidation cost is more than 7 lakhs.
No, I am saying who are there in the COC if there are no stakeholders?
So there is no COC on, there is no stakeholder because they had submitted their claim at the time of CIRP period, but during the period of liquidation, they have not submitted any claim.
But now the regulations are amended, no? Now they.
So this is the new one, but this case is older one. This 2020 case is there.
As per the amended regulation, you have to reconstitute SCC within 60 days, and they will definitely form part of the stakeholders.
Go with the original earlier claims also.
I'll just show you. These are applicable to everybody.
Retrospective.
I'll just show you just a moment. It's not retrospective, it is prospective. The regulations, what do they say? Within 60 days, you have to provide it where a consultation committee has been constituted before commencement of amendment. The liquidator within 30 days of the commencement of the said regulation shall reconstitute the consultation committee as required under law. So I think your answer would be here. Shall reconstitute. Can you read it?
Yeah.
So I think first of all, your first, you don't have a choice. Basically, you will have to reconstitute the SCC, put it before SCC, and then proceed ahead. And you should actually do it immediately because see, I have even yesterday only I appeared in one of the matters of DC before IBBI. The allegation, or I would say the contravention, was this only, that the amended regulations were not complied by the liquidator. So I think you will have to immediately reconstitute it. So that will solve your problem, because ultimately if SCC decides to sell something, And whatever is the reserve price, if they want to sell it above that, no problem, private sale can be done. If they want to reduce it, then NCLT approval will have to be done. And ultimately, what you are saying now, I don't know how this is going on, but 7 lakhs and 2 lakhs, this deficit, who will pay you? That is also a challenge.
So this is the problem where in the company there's no cash flow. So how we will recover our expenditure?
In such a situation, normally, if you see 39 BCD regulations, they say that liquidation cost has to be contributed by the COC members. And if they are not ready to contribute, then the process has to be terminated. And there are judgments of NCLT where the process has been terminated. Because if there is no taker of the cost, how will you close the company?
Right, sir.
So that process then and themselves has to be terminated. In fact, I have faced such cases also where even the bankers after the CIRP don't want to run into liquidation, and they withdraw their claim and the process is closed then and there.
Great, sir. Sir, one more question can I ask?
Please, if nobody is asking any query on the judgment, I can take other queries. I have no issue. Please.
Sir, 1 minute, sir. What Soni ji पूछ रहे थे? Actually, earlier CARP में जो भी claims हुआ, those claims have to be carried forward. That is also one of the amendments.
Yes.
So, if there are no claims now, the earlier claims of CARP has to be taken into cognizance, and with those members you have to constitute an SCC.
Correct.
Okay, right.
Yes, Sonuji, please.
Sir, actually, you want to know that if there is a financial creditor in the company, which is banker, and one office property is there, and we have put it 8-time e-auction this property, but no one has taken this property because of this Vastu dos. Vastu dos is there in the property. So many buyers have seen, and they were quite interested. And after seeing the floor plan, they are not taking this property. So what I should do, because this property was earlier ED attached. So after 2 years, I get back from the ED and defreeze the property. And now NCLT is saying what you are doing since long, why we will give extension, and 8-time all options has been failed. So now what should I do, sir?
So basically, if somebody is not coming up, ultimately you will have to keep on doing auction. But if your SCC is there, then you will have a comfort, because there is also a provision of onerous property. If selling cost is more and the recoverable value is less, then you can leave that property. The rights of that property can be released. One of my matter, we have also done it. You can just note down the citation that might help you. It's in the case of JR Diamond Private Limited, and the name of liquidator was Vinod Tarachand Agarwal. It's a NCLT Ahmedabad judgment with regard to onerous properties.
Okay, sir.
So that might help you.
Thank you, sir.
Welcome. Any other query, participants? So I am supposing that there are no further queries. I'm seeing so many participants. In fact, Prachi ji has left, I think. Okay. So Anuji, are you?
Yes, sir.
So Anuji, I suppose there are no further queries.
Yes, so we can close the session. Thank you so much, sir, for taking up the session, and such an interactive session it was. Thank you, sir, and thank you for sparing the time and taking the session. Thank you.
Thank you so
Thank you to all the participants also for taking up the session.
Thank you everyone for a patient hearing, and sorry I could not make the PPT because I was actually having some confusion on the date of the program. Thank you everyone. I have shared my email ID and number. Thank you everyone.